SJC-10398, Commonwealth v. Michael Jackson.
Good morning.
Good morning, Mr.
Emmanuel Howard for Michael Jackson.
Hang on a minute.
Hold a sec.
Nope. Go ahead. You're all set.
Thank you. We want you to address and revisit the duress question in a murder case insofar as it applies to an actor such as Michael Jackson, a juvenile with inherent impairments of a juvenile and also personal impairments on top of those. And we want you to take a view through the eyes, that is, the deficits and impairments that 21st century science and law recognizes in a juvenile with his baggage. Juveniles are different. This court has acknowledged that many times. And the inherent deficits and impairments of their youth, plus Jackson's particular impairments, must be taken into proper consideration in a murder case. Revisit it, if you would, as a complete defense, that is duress, as mitigating circumstances negating malice, or in, as the court said in Vasquez, the exceptional and rare circumstances present here where justice warrants reduction of guilt to manslaughter under General Laws, Chapter 278, Section 33E.
Well, I mean,
this is not,
he came down the street with a gun, went up to a guy and killed him.
Yeah.
Shot him.
Yeah.
5 times.
Yeah.
That's, okay.
Yeah, but he's got the recognized impairments inherent in a juvenile, and he's got evidence in this case of being threatened and being in a dysfunctional setting and trapped in his own neighborhood. There's evidence of his age, inherent impairment of a juvenile, his particular impairments as shown by Dr. Zeisel and Mrs. Hawkins in an offer of proof, and also Sergeant Keeler. He has family dysfunction. He has a very, very tough neighborhood and experience of people being able to carry out threats in that neighborhood. In particular, look at the management, and I'm using the word orchestration, but the way that Ricardo Green set up this entire thing through Big E and the threat. In fact,
Big E was in jail.
Big E is in jail, but his arms and his threats reach out to the neighborhood to the point where Ricardo Green cased the scene, found out where that Mr. Lane was there with another person, didn't identify the other person, who turned out to be Dew, and then made sure that Jackson got a gun, a semi-automatic pistol, and went through and carried the and went to the scene. Now, in importance of this is that when you get to scene, take a freeze frame view of that scene. He walks up and he sees Dew. He didn't know that Dew was the second person that was the person that was talking to Lane until he got within arm's reach. And yet he carried out the shooting. He shot once. 5 bullets came out. which indicated well, you can draw a reference that he wasn't familiar with that kind of a weapon. And it's interesting that why did he carry this out? Why would a reasonable person carry this out when there's an eyewitness who knows him? If he wasn't had this overwhelming view of an imminent threat that could be carried out very quickly, and because of his impairments, not only as a regular juvenile, an average, so-called average juvenile, but with his impairments of ADHD and other dysfunctions that Dr. Zeisel testified to.
So what are you asking us to do? I mean, how can we accept that as a proposition of law that you're not guilty of an offense if the circumstances you describe are present? I mean, under that theory, I mean, we've got suicide bombers all over who are young people being directed to place bombs, and there's some threat to their lives. Are we going to say it is okay because they were threatened?
Excuse me, I don't agree with your suicide bomber analogy. This was Jackson is in a closed-off setting.
Well, but his father's fiancée is a police officer.
I'm sorry, what?
According to the prosecution, I gather that his father's fiancée is a police officer. Is that?
Yes.
So there's people he could talk to, I think is the point.
There's people he could talk to, but in this neighborhood and in this setting and with his deficits, this is a question of you're assuming that he's a reasonable guy, but he's not.
Well,
he's not a reasonable guy because he has these inherent deficits that the average adult wouldn't have. You're treating him as an adult, and he's not. And you're also also forgetting that he has additional baggage of having ADHD and all of the other impairments that Dr. Zeisel states, and all of the constraints on him that came in through the offer of proof. So this is not, we talk about this reasonable adult and reasonable person in the duress case, and we use reasonable people, reasonable man in many categories in both the criminal side and the civil side. But here we know that the 21st century says, cases say and sciences say that this is not or should not be applied to a juvenile.
And of course, the result of that is that, in contrast to an adult, for him, I think, in 15 years, he'll be parole eligible, correct?
I'm sorry?
In 15 years, he will be parole eligible.
And in 15 years, as I said in my reply brief, is an illusion. Is illusion. He's going to be eligible, only eligible. That means that he's got to still wait. That he's not going to be sprung in 15 years.
Okay, so he's 18 years, even if you take your view.
Or maybe, well, you know, and he could be set back. Take time for the parole board to give him a hearing. That may take several months. Take time for the parole board to issue a decision. More months. There's been an average on second-degree lifers of about 8 months, average. So if he's even on the average, you may be talking about another year. Then if he's not successful, that means the parole board, using its very, very broad discretion, doesn't like the way he did this, or doesn't like the way he did that, or feels that he should have taken programs and he didn't take them, or didn't carry out programs, or something like that. But whatever whatever their evaluation of the standards that they set up, they could set him back another 5 years. And then, if he's fortunate enough after the 5 years, on top of the year that he's waiting, he's going to be he could be granted parole, again, waiting for a hearing and so forth and so on. And usually there's a tail on that because he's going to be told that we're granting you parole, but you have to spend at least a year in minimum security, because all of the first-degree murder people in this correctional system are in maximums. They can't go any lower because of the DOC classifications. So then spend a year in minimum, and then go over, follow other restrictions and instructions and conditions for the rest of your life. If he was convicted of manslaughter, he's 15 years, 20 years, if it's max 20 years, and he's free. He's done. He doesn't have anything hanging over on him in that particular case. So that's the difference, and I talk about it extensively in my reply brief. If I go on, this is not a slippery slope, and you would not be opening the floodgates. The common law way that a jury would view the situation and the actor is in the Commonwealth versus Robinson, Commonwealth versus Vasquez definition of duress. And this is talking about, there are 3 different places where these cases talk about reasonable. Every 3 separate judgments on what is reasonable under those circumstances. And this juveniles as a class, and this particular juvenile is not a reasonable adult. This is set up, the common law way of being reasonable is a reasonable adult. But this is
Mr. Howard,
a different scale. Excuse me.
One of the points, I think, of Vasquez is, on the other side of this, you've got the duress making a crime for which there is no more serious. I mean, so there's a value there that it's not just a sort of balancing of harms when the harm in question is actually killing another person.
Yeah, the choice of evils rationale, yes.
Yeah.
Right, and the harm, but again, that was set up dealing with the average reasonable adult in society, and these juveniles, and Jackson in particular, is not reasonable. He's not a reasonable adult.
But it's also a reflection of a major policy decision.
Yes, a major policy decision.
That someone cannot kill someone.
Well, yes, you know something? If you look at 20 section general laws, the
abuse.
I'm sorry.
Battered woman.
The battered women syndrome statute 23F. It talks about, in the trial of criminal cases, charging use of force, and it doesn't preclude murder against another, where the issue of defense or of self or another, or defense of duress or coercion, and so forth. Defendant shall be permitted to introduce certain evidence establishing the reasonableness of the defendant's apprehension. So this is particular defendant, not an adult, or it could be an adult, but what if it's a juvenile?
But it's based on
but
it's based on the conduct of the victim.
I'm sorry?
It's based on the conduct of the victim towards the defendant.
Based on, well, his establishing the reasonableness of the defendant's apprehension that death or serious bodily injury was imminent to him. to the defendant, or to the woman, in this case, the battered woman. It's what it is to her. Included in that is her or his experience in that setting. And Jackson had experience in that neighborhood and knew who was who and what was what, and that this threat from Big E, whether he was in prison or not, was real and imminent, and that Green was there to maybe carry that out. This was an organized by Green procedure, and he just got him there. And whether or not we're talking about reasonableness of apprehension, that death or serious bodily injury was imminent, it's imminent to him, Jackson. And reasonableness of the defendant's belief that he had availed himself of all means of avoid physical combat was also Jackson's experience. He had a dysfunctional family, set back and forth in foster care, set back in his neighborhood. There was nowhere to go for him. And you have to give the jury that instruction and ability to evaluate that setting, the entire setting that Jackson was under in that particular case. You have to give it to the jury, and the juries are capable, because these are impairments, if you're talking about that, and we on the criminal side, we talk about impairments in instructions all the time on his specific intent, on various issues that I've set forth in my brief, and in specific intent, primarily looking at Pike and Boateng, that if somebody has an impairment on any of the prongs of malice, that's a relevant discussion and ability that the jury has given, and we set this up in our model instructions. There are impairments all the time, and I give you illustrations of it in my brief. So therefore, and his perception of the reasonableness of the amount of force necessary to deal with that so-called threat. So again, freeze framing when Jackson is led by the nose almost through this setting of getting the gun. This is where you go. This is where you find Mr. Lane. And he walks down the street, and when it close by, he sees Dew. And he doesn't run away. He carries it out, fires one shot. And, interesting to the way as an illustration of a picture of his mind, a reasonable person, a reasonable adult, bent on assassinating somebody, would have shot and killed Dew on his way out. Dew turned around and ran down the street, heard shots. He didn't see it, but he saw Jackson pull out the gun from the back of from his back, fire, aim. He's down the street. After the gun goes off 5 times with one bullet, he doesn't aim it at Dew. That's unreasonable in that twisted sense, but he didn't. So this is a picture of a juvenile with not only this built-in inherent deficits and impairments, but exaggerated and exacerbated impairments. And that's why and incidentally, on 23F, battered women, there's no public constituency that would be backing duress of any plain individual. But there was a public constituency that would be backing battered, duress circumstances for battered women. But we have this common law, and you have the right under the common law to revisit that and ask a jury to apply the evidence, apply proper instructions, and apply argument to these deficits as it contained in a murder case.
All right.
Thank you very much.
Good morning, and may it please the court. Helle Sachse on behalf of the Commonwealth. The court should affirm the defendant's conviction for murder in the first degree and affirm the denial of his motion for new trial. There simply was no evidence in this case that amounted to this court's definition of duress, so that argument fails first and foremost on a factual basis. Secondly, it fails on a legal basis because this court has held in Vasquez that duress is not a defense to intentional murder. And thirdly, as Justice Gans has already hinted at, it would be a very morally unjustifiable outcome if murder were justified at the hands of juveniles, or they could be enticed to commit murder, and such murder would go unexcused. Therefore, this court should not revisit that question.
Is there also a question in this case about, what was the jury instructed with respect to the juvenile and any impairments he might have had? I know there was a forensic psychologist who testified, but was that?
Correct. His testimony was solely limited to the question of voluntariness of the defendant's statement to the police. And
so it was admitted at trial on that question alone? On that question alone.
Judge Brady instructed the jury immediately after the testimony that that was the limit of that testimony. And
was there a request for any instruction on mental, sort of impaired mental capacity that would lower the degree of murder?
There was not, Your Honor.
Well, what was the basis of the psychological testimony for voluntariness? Can any of it relate to the question of impulsiveness?
He testified about impulsiveness, but could that? But it wasn't argued that way.
No, it wasn't. It was the purpose of it, and it became quite clear during Dr. Zeisel's testimony, which was followed by the testimony of Sergeant Detective Keeler, who was also called by the defense. The purpose was to show that the defendant would follow the instructions of a police officer if provided. That he would, if the police told him to make a statement, as they did here after he was arrested, that he would follow that instruction and would be in that way.
It wasn't used at all that he would follow the instruction of Ricardo Green.
Quite to the contrary, Your Honor. The testimony came out that he would be more inclined to follow the authority of a police officer.
Well, but Ricardo Green is, I take it, a sort of superior in a hierarchy of whatever. But somebody who's leading but it wasn't used that way at all.
No, it wasn't. If this court has no further questions, I would ask you to affirm the conviction and to decline to exercise your review pursuant to 33E. No, not decline to exercise a review, but not reduce the conviction for this cold-blooded murder of Jose Lane. Thank you.
Thank you.